UK law. And what that has basically meant is that the government have had to bring in legislation to restate some of these European provisions in United Kingdom law to plug the gap. So rights that employees enjoyed under EU law can no longer rely on EU law from the 1st of January. And the government has introduced regulations to effectively put that into UK law officially for the first time. And that's the reason in particular for some of the changes we're going to look at today, not all of them, but some of them, and certainly some of the Equality Act changes. So that's, I think, the background and the landscape to why there maybe are more changes than we would expect for this particular update session. I'm going to hand over to Katie now anyway, and she's going to look firstly at some changes to the Equality Act. Some of these are certainly brought in for that reason to continue rights which employees previously had under EU law, now expressly forming part of UK law.
Thanks, Douglas. Now, as Douglas had said, some of these legislative changes are really to write into UK law what was already the position. So these are already arguments that could have been made relying on decisions by the European Court of Justice, but they've been officially written into UK law. So the first point relates to discrimination related to breastfeeding. So it was previously the case that an employee could make a claim of direct discrimination on the grounds of sex in relation to breastfeeding, but specifically not if it was related to an incident in the workplace. Now, that has been repealed following a decision of the European Court of Justice some years ago and now written into UK law. A slightly more substantive change, or rather writing into the UK law, is in relation to indirect discrimination. So some of you may know that generally a claim of indirect discrimination will apply where an organisation implements a provision, criterion or practice that's implemented equally to all, but it has an indirect disadvantage on a group of people who share a particular protected characteristic. So, for example, if an employer has a policy that requires employees to work from 9 to 5 each day, that might indirectly discriminate against women on the basis of their sex, because they might be more likely to have child caring responsibilities, pick up from school, pick up from nursery. And generally, claims of that nature would be raised by women who share that protected characteristic and that disadvantage. Now, the claimant actually need not have the relevant protected characteristic to make an indirect discrimination claim, so long as they suffer substantively the same disadvantage. So, for example, if a man in the workplace is disadvantaged in the same way by that policy of working 9 to 5, he might be able to raise an indirect discrimination claim, even if he's not part of a wider group of men who are disadvantaged. So it's not an argument that we've seen run often, even before when we had the European Court of Justice decision, but it's one that might be on the rise going forward. The next change I wanted to have a look at was in relation to general discriminatory statements about recruitment. So we've had confirmation now in UK law that it will amount to direct discrimination if an organisation makes a general discriminatory statement about recruitment, even if there's no ongoing recruitment or active recruitment exercise, and also crucially, even if there's no identifiable victim. So for example, if an organisation was to place a notice online or on their window that stated that they did not employ men, or they didn't employ people of a particular ethnic origin or race or religion, that can still amount to discrimination even when there's no identifiable victim, and that's enforceable by the Equality and Human Rights Commission. The fourth point we wanted to flag was, again, it's confirmation, but it's of the single source test in equal pay claims. And that's the idea that for the purposes of identifying a comparator in an equal pay claim, an employee is entitled to look beyond their employer organisation or associated organisations and can actually identify a comparator at a completely different organisation, so long as the same body lays down the terms and conditions for both of those organisations. So it's maybe not likely to apply that often in practice, but an example is in the social housing sector, where we have different housing associations, but the terms might be set by the union and employers in voluntary housing. So it's not totally uncommon, and just again something to bear in mind. The last point, just in relation to these Equality Act changes, is quite a significant one in our view, and it relates to the definition of disability in the Equality Act. So the standard definition is that someone has to have a physical or mental impairment which has lasted or is likely to last for more than 12 months, and which has a substantial and adverse effect on their ability to carry out normal day-to-day activities. Now, what the tribunals generally interpreted normal day-to-day activities as, was your household activities, putting on a washing, making a cup of tea, general cleaning in the house. But the definition has been expanded to include an employee's ability to participate in their working life. So your organisation now, if you're considering whether an employee might be disabled, under the Equality Act, you have to look a bit more broadly, not only at their ability to carry out day-to-day activities and how that's affected by any mental or physical impairment, but also how they're able to participate and kind of fulfil their workplace duties. A separate change to the Equality Act was brought in by the Worker Protection Act 2023. And I should have said, sorry, the previous changes came into effect from the 1st of January this year. They're codifying the current position. This new duty to prevent sexual harassment isn't expected to come into force until around October this year. And we are awaiting a code of practice in relation to this. So it's still some details to be confirmed, but we are aware that this amendment will introduce a new positive duty on employers to take reasonable steps to prevent sexual harassment of their employees. Now, it's not a duty to take all steps, it's a duty to take reasonable steps, and there's still a bit of a question mark over what that might entail, but we're expecting some guidance from the Equality and Human Rights Commission on that point in due course. Now, this stands alongside rights that employees already have in relation to sexual harassment. So if an employee raises a sexual harassment claim, your organisation might have a defence to that if it can show that it took all reasonable steps to prevent that. This is a new positive duty, sort of front-loaded. It's not a freestanding claim, but the real consequence for your organisation is that on occasion that you do lose a sexual harassment claim, if you haven't taken reasonable steps, the tribunal has the power to uplift any compensation by up to 25%. The policy, isn't set in stone as yet, so we are waiting for further details on this, but certainly the Act is expected to come into force in October of this year. We wanted also to look at some changes in relation to family leave provision and some other general changes, and the change in relation to redundancy protection, in our review, has sort of garnered quite a lot of press attention, so it might be one that you're aware of already. But at present, the current rules on redundancy protection only apply to employees who are on maternity leave. And what I mean by protection is that if an employee on maternity leave or adoption leave or shared parental leave finds that their role has become redundant whilst they are on leave, they have to be offered any suitable alternative vacancy, and they have first refusal on that role in preference to other redundant staff. Now, that obviously doesn't prevent an employee on mat leave being selected for redundancy or ultimately dismissed, as long as there's been a fair process and objective selection criteria. But that obligation to give employees' first refusal for suitable alternative roles is only applicable where an employee is on maternity leave. However, from the 6th of April onwards this year, that protection will actually apply from the day the employer is informed of the pregnancy. So when employees are still in situ at work and haven't yet gone on maternity leave, they will have that right of first refusal if a redundancy exercise is in place. And that protected period, rather than ending when an employee returns from maternity leave, it will actually last for 18 months from the expected date of childbirth or the actual date of childbirth. So that's quite a significant extension. Generally, most of our clients, if they're going through a redundancy exercise, they look at their staff pool and work out whether this protection is applicable. And normally that's quite easy because you're just looking at whether or not you have any employees on maternity leave. But from 6th of April onwards, you're really having to have a detailed records of who was on pregnant, who was on maternity leave, and the birth of the child, because it would be quite an easy one to miss out on just in relation to timescales. So in our view, that's a very significant change and something that you should all be aware of. Another new introduction of entitlement to this time carers leave, which was passed on the 24th of May and is expected to come into force on the 6th of April this year, albeit the draft regulations are currently being debated before Parliament. But based on what's being discussed at the moment, this legislation will create a new day one right for unpaid carers to take up to a week of unpaid leave per year when they have a dependent with a long-term care need and they need that time off to provide or arrange care for that dependent. Now, a dependent has quite a broad definition. It's a spouse, civil partner, parent, child, someone who lives with you, or someone who reasonably requires your care. And a long-term care need is a care need that's expected to last for 3 months or more. A disability, as defined in the Equality Act, which we've touched on, or if someone needs a person's care because of their old age. Now, this right to a week's unpaid carers leave can be taken in half days or full days. But crucially, employees have to give notice of their intention to take that leave. Where they're looking to take a half day or a full day, they have to give at least 3 days notice. And if they're looking to take 2 days or more, they have to give double the amount of notice than the days leave. Now, employers will have a right to postpone a request under the new legislation. They don't have a right to refuse a request, but they can postpone it. They have to notify employees or workers of the postponement prior to the date the leave was due to commence. And they also have to give written reasons and a counter notice within 7 days of the initial request. So given that the request might only be a request for 1 day and 3 days notice, I think most employers will have to just give the written counter notice on the 3-day point. I would expect most to speak to the employee before the leave was due to take place. But also, even when a postponement is made, the employee has to take the initially requested leave within a month of that request. So again, something to be aware of going forward. And I think also to bear in mind that carers who need emergency leave can probably still rely on unpaid time off for dependents. This legislation is looking more at leave that can be foreseen and booked off in advance. There's also been a couple of minor changes to paternity leave. Going forward from 8th of March, so slightly earlier for this change, paternity leave can be taken in 2 one-week blocks rather than having to take both weeks consecutively. And the leave can also be taken in the first, any time in the first 52 weeks following birth, rather than being restricted to taking it within the first 56 days. The notice of entitlement to paternity leave will still have to be given 15 weeks before the estimated week of childbirth. But in relation to the precise dates that the individual wishes to take the leave, that the notice requirement for that has been reduced to 28 days. So an employee's not having to, decide when they're taking their leave 15 weeks before the estimated week of childbirth. They can let you know the situation when the child is due to be born, but then wait for giving the notice for that. There's also been some changes to the flexible working regime, which again have been well publicised in the press. There's really 5 key changes, all coming into force 6th of April. So the right to request flexible working will become a day 1 right, rather than requiring 26 weeks service. And that's a right to make a statutory flexible working request rather than an informal request. Employees will be able to make 2 flexible working requests per year, as opposed to 1, as is currently the position. There was or is a requirement for employees to explain the effect that they think the change would have on the organisation and how that might be dealt with, although that has been removed. The 4th is that employers now have to consult with employees before rejecting a flexible working request. I suspect most employers would do that anyway by virtue of considering the request, but there is a positive obligation to do that now, and how much consultation is required remains unclear at present. And importantly, for all employers to know that the time limit for coming to the conclusion of a statutory flexible working request has been reduced from 3 months to 2. There is still the option to agree a longer period with the employee, but on the basis that can't be agreed, you're having to deal with these requests in a much quicker timescale than before. ACAS have produced a draft code of practice on requests for flexible working, which is open for consultation, and it's expected to be finalised before the 6th of April. So that will be a useful tool for all of you in kind of formulating how you deal with these requests going forward. There are also some sort of miscellaneous changes that we wanted to touch on. The last point from me is just quickly on predictable working patterns, which will be relevant to any of you who have staff who work irregular hours. Now, the Act will come into force in September of this year and will give workers and agency workers the right to request a more predictable working pattern if their working pattern lacks predictability in relation to the number of hours that they work, the days and times that they work, or the length of their contract. Now, similar to flexible working, this is a right to request predictable working patterns. It's not a right to a predictable working pattern. So it's expected that employers in industries such as hospitality that heavily rely on unpredictable hours will still be able to do so, but they will have to follow a process to deal with these requests. And similarly to flexible working, we've got a draft ACAS code of practice which sets out what that's likely to look like later in the year once it comes into force. This wouldn't quite be a day 1 right, it would be 26 weeks service. But again, 2 applications within any 12-month period. And there are some usual statutory grounds of refusal, the main one being if it doesn't suit business needs and it would reduce the efficiency of the business. So I'm going to hand over to Douglas now, who's going to chat about holiday pay.
Thanks very much, Katie. Yeah, holiday pay, perhaps the area where there's been the most significant, probably the highest number of changes as well. A number of changes, which is important to note there for leave years, which begin after the 1st of April 2024. So if in your organisation your holiday year or your leave year runs 1st January to 31st December, then this isn't going to affect you until 1st January 2025. So it's the first leave year that starts after April this year. The first change we need to be aware of, it really is just one of these points again that's putting into UK law what originally was a right resting in EU law, which is that for the basic 4 weeks annual leave a year, which is based in European law, a week's pay must include commission and regular overtime payments worked in the previous 12 months. That doesn't extend to the additional statutory 1.6 weeks, but for the basic 4 weeks a year, we now have in UK domestic law the requirement to include commission and regular overtime pay. But that has been in practice a position for years now, and is something that all employers should be doing when they work out a week's pay to pay in respect of holiday. I think the more significant changes, though, are in relation to part year and irregular workers. It doesn't apply to all employees or all workers, it's only part year and irregular workers. And an irregular hours worker is someone where the number of paid hours that they work in each pay period during the term of their contract wholly or mostly is variable. So a fairly obvious definition, I think, if hours of work for which the employee is paid are wholly or mostly variable over the course of the contract, then they are an irregular hours worker. A part year worker is someone who is engaged by the employer throughout the year, but under their contract, they only work part of the year, and there are periods of the year where they are not required to work and for which they are not paid. Typically, that might be someone engaged in a school or another educational institution where they work term time, they don't work during holiday time and are not paid for that holiday time. They then would be a part year worker. Now, working out holiday entitlement for part year and irregular hours workers was often traditionally quite complicated. What a lot of employers did was they applied 12.07% to the pay received or the hours worked, and that formed the calculation for how much holiday entitlement there was. The argument was you can't be due 5.6 weeks over the course of a year if you don't work the whole year. And in terms of people whose hours vary, well, how do we work that out? We just apply 12.07%. And there was some support for that even in ACAS guidance. But a couple of years ago, the Supreme Court in the Harper Trust against Brazil case said that's not allowed, that's not consistent with the working time regulations. You can't use 12.07%. It has to be 5.6 weeks statutory leave for all workers, no matter whether they're only term time and no matter whether they are irregular. And so this legislative change is really an attempt to reverse the Supreme Court's decision in Harper Trust and now make it part of UK domestic law that in fact employers can use the 12.07% accrual method. So if you have a part year or a regular worker, and that's all, not all workers, but if you have a part year worker or an irregular hours worker, you can work out their holiday entitlement in terms of how many holidays accrue or 12.07% of the number of hours worked. That is now legitimate. When we move on to the related question of, okay, we know what the holiday entitlement is, but how much is paid? Well, there's two options now for these types of workers. There's two options for how that holiday pay is to be paid. Rolled up holiday pay is now expressly allowed. For many, many years, the position has been that rolled up holiday pay isn't allowed. And by rolled up holiday pay, I mean that when an employee works, let's say they work for an hour, they get £14. 2 of that is their holiday pay, £12 of that is their remuneration for the work. For years, that's not been allowed. That's now permitted using that 12.07% calculation. So you're entitled to add on 12.07% of the agreed remuneration, and that is paid at the time the work is done as holiday pay, rather than paying it at the time that the holiday is actually taken. That needs to be shown clearly on the payslip as holiday pay. So that is one option. The other way of paying holiday pay under this 12.07% accrual method is that you pay the holiday pay at the time the holiday is taken. And in working out what a week's pay is, you look back at the average remuneration over the last 52 weeks in which work was done. So it's a two-stage process. Firstly, how much holiday is accruing? That's 12.07%. Then how do we pay it? It's either paid at the time the work is done as part of the hourly rate, although separated into different elements, or we pay it at the time the holiday is actually taken, which would need to be booked in and taken in the normal way, looking at an average. So it's really quite significant changes, really complicated. The government guidance is very long, very complex, but it's really important. The next slide really just covers some changes which, again, are bringing into UK law rights which already existed under EU law, and it talks about the carry forward of annual leave entitlement into subsequent holiday years. So it says expressly if an employee or a worker can't take their annual leave under statute due to taking family leave, such as maternity leave, etc., then they can carry that full entitlement over into the next holiday year. And that's always been the practice and the understanding. If they can't take their full annual leave entitlement due to sickness absence, then they can carry forward 4 weeks into the next holiday year if they've not been able to take their basic initial 4-week holiday entitlement. They can carry that into the next holiday year, but that will expire if not taken within 18 months after the end of the holiday year in which it actually accrued. Equally, if the employee or the worker has not taken or been able to take their holiday entitlement because the employer has not given them the opportunity to do so, then 4 weeks can be carried forward, but in this case can be carried forward indefinitely, year after year. What does that mean? Well, my concern is for organisations who use consultants or contractors or people who are viewed as being self-employed, and they're told, no, you don't get paid holidays, you're a contractor. And then years down the line, a claim goes in and employment tribunal says, well, actually, you weren't genuinely self-employed, you were a worker. And as a worker, you're entitled to 5.6 weeks paid annual leave every year. Your employer didn't give you the ability to take that annual leave. Therefore, that has carried forward 4 weeks every year, year after year after year. And there's now this huge entitlement to paid annual leave. So be very careful if you engage or make use of individuals who maybe are treated as self-employed, don't get holiday pay, but could in fact be workers, because that entitlement could carry forward if you're not allowing them to take paid annual leave. Staying with holiday pay, and this has been a long-running issue dating back to Bear Scotland against Fulton a good number of years ago, looking at a situation where holiday pay has not been calculated correctly, where it has been underpaid because it doesn't include elements of overtime, commission, bonuses, etc. And what the Bear Scotland case said is that if you're looking back as to how long going backwards a worker can claim for, if you hit a 3-month gap where there were no deductions, no underpaid holidays, then that 3 months breaks the chain or the series of deductions and the claim can't go back any further. So rather than saying you've underpaid me for the last 5 years, it might only be 6 months if there is a 3-month period where there were no deductions. The Supreme Court in a Northern Irish case of Agnew has said that isn't correct. That's not the law. You don't need a 3-month. You don't need to ensure that there is no 3-month gap. Even if there's a 3-month gap, there could still be a series of deductions, and therefore a claim for unlawful deduction of wages for underpaid holiday pay could go back way beyond that 3-month gap. But there is, by statute, a 2-year limit in Britain as to how far you can go back. So a claim for unlawful deductions can only go back 2 years. But we no longer care about whether there's been a 3-month gap. That will usually be irrelevant. You just need to look at all the circumstances of the case and assess, has there been a series of deductions, a series of occasions of underpaid holiday pay. TUPE transfers, and I'll deal with this fairly briefly. You will be aware that if your business is involved in a TUPE transfer, there are obligations to inform and in some cases to consult with employee representatives. And the current position is that if you are the transferor, you're the old employer transferring your business elsewhere, you have an obligation to provide information to elected representatives of your staff. And if there are no elected representatives in place at the moment, you need to carry out an election, then you provide information to the reps, and if appropriate, you consult with them. And the only exception to that was very limited, which was if your business, your entire operation had fewer than 10 employees in total, irrespective of how many people are transferring. That's not the point. It's does your business have fewer than 10 employees in total? If so, you didn't have to go through this election process. 10 or more, technically, although it was often not done, technically, you need to have the election. If you're having a TUPE transfer now after the 1st of July this year, then there are fewer circumstances in which you would be required to have an election. So if you don't already have elected reps and you have fewer than 50 employees, then you don't need to carry out an election of employee reps. And however many employees you have, if the transfer involves fewer than 10 employees transferring to the new employer, then you don't need to carry out an election of representatives. You can give the information to all employees direct, and if applicable, consult with all employees direct. However, if you already do have employee reps in place, or you recognise a trade union for consultation purposes, then you're still going to have to deal with the reps. This is only applicable if you don't have reps in place. So I think it's quite significant, but the reality is that a lot of employers didn't necessarily go through the election process anyway. But it's important to be aware of that if you're going to be going through a TUPE transfer. Very briefly, I want to touch on the Strikes Act, which introduces new powers to set out minimum service levels in key public services. Probably not something that's directly relevant to a lot of those attending this session, but it is controversial legislation. It allows minimum service levels to be set, and therefore preventing people striking in order to meet the prescribed minimum service level. And the TUC have called it an assault on the right to strike. There's also been questions about whether it's compatible with human rights obligations. National living and minimum wage increases coming up as normal later this year, and they're set out on the slide. Just be aware of those. I think the significant thing there, I think, is the age threshold for national living wage being reduced to 21. So that is going to impact on wage bills. That the full national living wage will apply to more people. So just be aware of that. That's something you could easily get caught out on. So looking forward, perhaps slightly beyond 2024, things that may be coming up in the future, and there's a number of them. Tribunal fees. You may remember a number of years ago, a claimant raising an employment tribunal claim had to pay a fee to raise the claim, a fee to have a hearing fixed, a fee for various parts of the process, and that could result in claimants having to pay a bill of £1,200, £1,500 overall, quite a lot of money. And then in 2017, the Supreme Court said that those fees were unlawful because they made pursuit of tribunal claims unaffordable, and if there was a low value claim, it essentially meant that the employee had no realistic remedy. So the fees were unlawful. Embarrassingly, the government had to repay the fees to everyone that had paid them before. And for the last 6-7 years, there have been no fees. The government is now talking about possibly reintroducing a fee to raise a tribunal claim. Suggestion is it would only be £55, which would cover the entire case. So far more proportional, far proportionate, far less unreasonable, and I don't think that would attract the same arguments about denying justice. So watch this space for that. Fire and rehire, it's something we blogged about recently. There is likely to be a new statutory code of practice in force later this year, which employers will need to comply with if they're going to fire and rehire. And all that means is to dismiss employees intending to re-engage them at the end of their employment on new terms. It's a way of achieving a change in terms and conditions. And it is a slightly frowned on practice, but it's perfectly legitimate if there's a compelling business need. And the code of practice is for employers to follow. And if they don't, and there's a claim, then compensation can be increased because they didn't follow the code of practice. Touching briefly on non-compete clauses, restrictive covenants, in other words, saying when you leave us, you, the employee, cannot go and work for a competitor and can't poach our staff and our clients, etc. Suggestion from the government was that they would bring in legislation to restrict the non-compete element, i.e. the ability to say to someone you cannot join a competitor. That would be restricted to no more than 3 months. No restrictions on clauses saying you can't poach our customers and clients, but in terms of saying you can't join a competitor, that would potentially be restricted to 3 months after employment ends. We're told this might be brought in when parliamentary time allows. I suspect that means never, but it will be significant for employers and something to really be aware of in terms of limiting the ability to stop someone leaving and joining a competitor. Neonatal care and leave is something which we understand will come into force in 2025. If there's a newborn child with a particular health need, it will give the parent, the employee, the right to take time off to care for that health situation. And of course, later this year, inevitably, we're going to have a general election. Labour have said what they're going to do. It seems potentially likely at the moment that they will form the next government. They've talked about a lot of potential employment law changes. For example, a single status of worker for all but the genuinely self-employed. So we wouldn't have these different groups, employee and worker, with different sets of rights. They would all be workers with the same rights. So that's quite a radical change potentially. Banning 0 hours contracts is more obvious. Being able to claim unfair dismissal from day one, so not a 2-year qualifying service requirement, not even 1 year, which has been in the past. Having the right to claim unfair dismissal from day one and potentially with no limit on compensation, that's a very radical change. And I don't get the impression it's something that anyone was really calling out for, being able to claim unfair dismissal from day one. But again, watch this space. Other potential changes: completely ban fire and rehire, address family-friendly rights, and quite a lot of talk about enhancing rights for trade unions. I think that's a key aspect of Labour's proposals and intentions, so that the right to strike is probably going to be strengthened. Equal pay, potentially, at the moment, employees can bring an equal pay claim if they're arguing a differential in their pay compared to those of another sex or gender. If that is extended to race and disability, then it would allow equal pay claims on those grounds as well. Some commentators have queried what the point is of that, because at the moment, paying people differently due to their race or due to disability is unlawful anyway. You could bring a direct discrimination claim. So does an equal pay claim really add anything to that other than just making things more complicated? Probably not. But watch this space. We don't know what will happen, but that remains to be seen. I don't know, Dawn, whether there's been any questions in the chat over the course of the session, but we're happy to field any questions.
Thanks so much. Thanks, Douglas, and thanks, Katie, as well. We do have a couple of questions, so I was going to just read them out to you. I think we'll do yours first, Douglas, and then we can go on to Katie's. Anne has asked, my understanding is that the part-year and irregular workers calculating holiday entitlement at 12.07% and rolled up holiday pay is not obligatory, but rather it is up to the employer to decide if they want to use this or not. And if the employer decides not to use, then the employee has to accept. Douglas, can you maybe give us some commentary on that, please?
I think I can't think of any situation in which I think the worker is always going to be better off if you use the 5.6 weeks calculation. So if you're going to use that calculation and the worker is going to get greater holiday entitlement paid at a higher level, then clearly that's going to be legitimate. No one's going to complain about that because the employee is getting 5.6 weeks paid at their normal rate rather than the accrual simply being on 12.07%. So no, I think I would agree with that. It's not mandatory. The law says how holidays would accrue under statute. But if an employer wants to say we're going to do better as a matter of contract, that would be fine. And I guess that's a point which maybe should be made more generally. If your contract commits you to working out holiday pay in a particular way, which is more favourable than the 12.07%, you're probably stuck with that. Just because the law says that 12.07% is allowed doesn't entitle an employer to breach the contract of employment. So if your contract of employment is explicit about how holidays are calculated, then you're going to have to stick with that, even if that's better than the 12.07% approach.
And I guess that may be correct for most contracts that predate the 12.07% legislation.
Absolutely, I think you need to look at it on a case-by-case basis, but you would certainly, well, even in the aftermath of Harper Trust against Brazil, when the Supreme Court said 12.07% isn't lawful, employers will have changed their contracts at that stage potentially to say, oh well, it's not lawful. I think our advice was, well, maybe wait and see what happens. And in fact, we're now told, like, reversing the situation again, you can use 12.07%, but if you've made a contractual commitment to something else, then you're stuck with it unless you get into ways of changing contract employment, and that takes you into fire and rehire and things like that.
Thanks very much, Douglas. Katie, I think this one's about objective justification, and it's from Sonia. Can I ask how you distinguish between what are the genuine needs of the business, i.e. 9 to 5 working, and people raising that they are being discriminated against because they need to collect the kids from school? I feel that it is being made impossible for businesses to stipulate what is needed to run effectively, as we are working around what duties employees are able to carry out around their family life oblique responsibilities.
Sure, so this probably stems from my example when I was talking about indirect discrimination and a policy, that might require staff to work from 9 to 5. Now, it's really crucial to know that indirect discrimination can be objectively justified in some cases where the policy is a proportionate means of achieving a legitimate aim. So it is tricky to have a sort of blanket answer. It will depend on the facts and circumstances of each case, but generally most businesses will be able to justify requiring employees to work from that from 9 to 5. So it really just depends on how proportionate the Act is, and that would be a defence to any indirect discrimination claim of that nature.
Thanks, Katie. We're at 12:45, so I think really we just need to wrap it up there. If you would like to, I hope first of all everybody's enjoyed the session. I've found it extremely informative, even speaking as an employment lawyer. If you'd like to be kept up to date with employment law developments and future training events that we're having at BTO, then please send an email to marketing@bto.co.uk. Otherwise, all that's left for me to do is thank you all for your attendance today. I hope that you've found today's webinar helpful. Thank you.